76 of At Your Service with Haber and Martinez. You may notice that it's only me at the moment because Martinez is still stuck in a Zoom hearing, and he will join us as soon as he can. I'll do my best to not bore you to tears in the interim. Today's episode is entitled Dissecting Yet Another Real-World Current and Local Criminal Case. What Ed and I, in trying to figure out what we were going to talk about today, went through the news over the course of the weekend and came across an article, which is not a very long article, although it's got an awful lot of tentacles and plenty that we can discuss as a result of it. I'm going to start by reading the article in its entirety, and then we'll kind of run through it as we get along during the course of the show. And as I said, hopefully Ed will be able to join us sooner than later, because I don't even want to hear myself talk for an hour. Anyhow, I want to just make a little disclaimer as I put on the promo materials this morning, so forgive me for reading this, but it is an important programming note with regards to today's show. Anybody who's arrested anywhere in the United States of America is presumed innocent. Many people tend to think that you wouldn't have gotten arrested if you didn't do something wrong. It is a bias and a prejudice that's inherent and built into the system, or possibly into human nature, or possibly both. But the fact is, I don't know whether or not this individual did what he's accused of. In fact, I'm about to tell you that I'm not even entirely sure what he's accused of. But regardless, anybody, anywhere in this country, for any criminal act, any allegation of criminality, has a Fifth Amendment presumption of innocence. And that sticks with them until the end of a trial, if the state is able to convince a jury beyond a reasonable doubt, or a judge in a bench trial beyond a reasonable doubt, that they've met their burden of proof in proving each and every element of every offense charged. So I want to start with that premise. This individual who we're going to be talking about today was arrested on September 29th, just a couple days ago, on this past Thursday, here in Miami-Dade County. He has two very serious charges, according to the news reports. Whenever anybody gets arrested here in the state of Florida, they're required to have a statement of probable cause. I mean, I assume that applies everywhere else, but I don't know anything about criminal procedure in any other state. So let's just stick with Florida. In order for the police to make a valid arrest, they have to state the basis and put you on notice. It's part of your due process rights as to why you're being arrested and what you're being arrested for. And that's called probable cause. In our case, we call it here in Miami-Dade County a complaint/probable cause, a complaint/arrest affidavit. If you cross the northern border and go into Broward, it's called a probable cause affidavit. Different jurisdictions have different terminology, but it all boils down to the same thing. It's a statement of facts sworn to under oath by the arresting officer as to those facts and circumstances that led that officer to believe that he had probable cause or she had probable cause to arrest a person for a specific offense. So in this particular case, I don't have the probable cause affidavit. I don't have that complaint arrest affidavit. I have not read it. It's not a public it is a public document, but it is not on the clerk's website. Interesting aside alert, in Broward County, if you get arrested, the minute that you're booked or within a very short period of time after your booking, your probable cause statement is on the clerk's website and anybody can read it because it is in fact a public record. It's one of the nice things about practicing in Broward is when somebody calls to consult me about a case, I can generally look online and read that police report. And another aside alert, again, I apologize, but it's very important from my perspective. Now, if you put 5 lawyers in a room and ask one question, you might get 5 different answers. Doesn't mean any of us are particularly right or wrong. It doesn't mean that, we have, some clairvoyance or anything. We just each have different ways of doing things, and we develop our skill set and our practice over time. Mine is, I don't want to hear from the client until I read the police report. I want to know everything that the cops say, everything that they swear to. What is their version of events before my client prejudices me with theirs? Because that way I've got the worst case scenario in front of me. Can't get worse. If you believe everything in that report, you should be guilty. And if I read things in that report that suggest that there are avenues of attack, to draw an analogy, if it gives me the ability to take a chisel and a hammer and chip away at the dam because I see something in there that doesn't make sense, or that reeks of some sort of improper procedure or protocol or tactic, or some constitutional or procedural violation, or if I see an element of the crime is missing, there are things in there that might give me a head start before I talk to the client. And the other the other side of that coin is once my client tells me their version of events, they can't turn around and change it later. So I don't really want to hear it until after I know what the worst case scenario is, because I don't want to be put in a position by a client where they say to me, and this has happened, oh, I'll say whatever you need me to say. No, it doesn't work that way. Everybody's got testimony, a version of events, whether you put it forth or not. And once you put it forth, you're pretty much stuck with it. So the first thing is, again, this individual is presumed innocent. The second thing I want to say is that I don't have that police report, okay, that complaint arrest affidavit. So I do not know what the formal allegations are. I am relying exclusively on one newspaper article because that's all I could find. I did find others, but nothing that contained any more information. So it's bare-boned information as reported by a local news network. I couldn't even find a video clip because apparently the news network looped over their current video the next day. And this, if it's there, it's more difficult to find than I was willing to put forth the effort to locate. So again, we're relying on that one report. And then finally, I want to say that I have not been reached out to. Ed has not been reached out to. We've had no contact with the defendant or any family member or representative on the defendant's side. So we really don't know anything about the case other than what we're operating on. And sometimes that's all you have up front to kind of come up with an assessment. And it's one of the reasons that I say, like Fight Club, the first rule of criminal defense litigation is expect the unexpected because anything can happen in a courtroom. So regardless of what the police put forth, regardless of what the newspaper says, regardless of what the defendant says, at some point in time, there will be a version of events that's accepted by all parties, the state, the defense, and the judge, whether they agree voluntarily or they're forced to. So that's my little programming note. And now let me get into telling you what this article is and reading it off to you. The individual's name is Gary Sebrin Hills II. He's a 35-year-old man who was arrested on Thursday, September 29th here in Miami-Dade County. According to the news article, he has two charges. The first is attempted second-degree murder. The second is aggravated battery with a firearm. So as you can tell, they're pretty serious charges. I did a little local research into Mr. Hills, and I do not believe that he has any significant prior criminal history. The only case that I was able to pull up was a aged misdemeanor marijuana possession case. So there's no violent felonies in his past, which obviously is a good thing. And he doesn't seem to have a very long rap sheet, which also is probably a good thing. But again, remember, when we look at these cases, we're looking at them from different vantage points. The police and the prosecutor are looking at it primarily from a perspective of proving a case, and the defense is looking at it from the other perspective of how to either poke holes in it or flat out disprove it. So with that said, let's go ahead and read the article. Miami-Dade County, Florida. Police arrested a man Thursday who they said shot a person in southwest Miami-Dade. According to an arrest report from the Miami-Dade Police Department, apparently the news agency has read the report, or at least they claim to, Gary Sebrin Hills II, 35 of Miami, is facing one count each of second-degree attempted murder and aggravated battery with a deadly weapon. Miami-Dade police officers said that they responded to a shooting call around 3:30 p.m. near the 10300 block of Southwest 173rd Street in the West Perrine area. Upon arrival, police said that they spoke to a witness at the scene who identified Hills as the shooter and said that he had left the scene in a brown sedan with a Florida license plate. Authorities said that they sent out a BOLO, a be on the lookout alert, for Hills and his vehicle shortly after the incident was reported. According to the report, Miami-Dade County police officers located a suspected vehicle traveling northbound on South Dixie Highway and Southwest 136th Street, where they were able to stop the vehicle and detain Hills. Before putting Hills in handcuffs, police said that they spotted a semi-automatic handgun on his lap. Authorities said that the gun was left inside of Hills' vehicle for police to investigate. Investigators learned that following an argument between the victim and a witness, the dispute became physical and both parties had to be separated. Police said following the argument, Hills left the residence and went into his vehicle. He then began to reverse when the victim grabbed a glass bottle from the home and threw it at his vehicle, but did not strike it, authorities said. Shortly after the victim threw the bottle at the vehicle, Hills pulled out a handgun, shot the victim, and then fled the area, the report said. Police said they later located Hills at around 4:45 p.m. near the 1100 block of South Dixie Highway in Pinecrest, where they took him into custody. After allowing Hills to drink some water and smoke a cigarette while being interviewed, Hills asked detectives, quote, "Is this about a homicide?" Investigators brought Hills into an interview room where he stated that he wanted an attorney present. As of Friday afternoon, Hills was being held without bond at the TGK Correctional Center. Miami-Dade police have not released any information on the victim's identity, age, gender, or condition in the arrest report. So there you have it. You now know everything that I know. Again, Mr. Hills was arrested on 2 very serious felony charges, neither of which, one of which he's entitled to bond on. That would be the aggravated battery with a firearm. That is actually aggravated battery is a third degree felony, and with a firearm bumps it up to a second, and also possibly subjects him to 10-20 life minimum mandatories. Attempted second degree murder is a first degree felony, and that actually it's a second degree. Yeah, it's a second degree felony, because second degree murder would be a first degree felony. Attempt would drop it down a level. So technically he should be entitled to a bond on that too. The question is, what happened at his bond hearing? I wasn't present, I wasn't there, and I can't tell you. But I can take a pretty good guess that the state attorney argued off of the police report, saying that he presents an imminent danger. He's reckless, he's aggressive, he's violent, he has access to weapons, he has poor impulse control. I can only imagine the things that they argued along those lines. Public defender sitting in the courtroom doing the exact opposite. Unfortunately, that arrest report is even though it's what we would call hearsay and it wouldn't be admissible in a trial, it is the fulcrum of that initial appearance / bond review. And in this case, the judge apparently felt that this should not be a bondable offense because he presented a danger to the community, but it could also be because he was a flight risk. Again, I don't know, I wasn't there. Here in Florida, that's basically the criterion. In Miami-Dade County, in every county actually, but let's focus on Dade, we have what's called a standard bond schedule. Every single offense that is in the Florida statutes has a corresponding bond amount. So when they type it into the computer, when an individual gets booked into the jail and they're given that PC report, that complaint / arrest affidavit, it's got a list of charges, whatever it is that the police have accused you of. Corrections just types it in. They don't review it, they don't edit it, they don't alter it, they don't question it. All they simply do is mimic it. They type in the numbers that correspond to the statute that the police officers wrote, even if it's an incorrect statute. They copy it verbatim, the computer spits out a bond amount, and if you don't have any other holds, in other words, if you're not on probation, if you're not out on felony bond, if you don't have a fugitive warrant or an extradition warrant or a writ of bodily attachment or an immigration hold or any other type of matter, then if you are bondable, you don't have to go to that initial appearance. Once you're booked into the system and that information is entered, the corresponding bond number is postable at any point in time. If you don't post in time, or if you have a non-bondable, or if you have some other hold independent of the case, then you have to go to that initial hearing. And there are some charges in Florida, for example, domestic violence charges require an initial appearance. You cannot post bond even on a misdemeanor DV case. But again, I'm running a little bit off on tangents here. So he gets booked into the jail. He goes to his bond hearing. The judge determines that he presents a risk, and they deny him bond. Now he's going to sit in custody. His case has been assigned to the Honorable Richard Hirsch. Judge Hirsch will arraign this case 21 days from the date of the arrest, which would put it out at about 28, 29, 30, about the 17th or 18th of October. And at that point in time, if the state is prepared to file charges, they will. And if they're not, then they will ask for an extension, and they will surely get one. If they hold him beyond 33 days and up to the 40th day, the court can still keep him in custody if he has not been charged. But if he's not charged by the 40th day, then he has to be released, regardless of what the charges are. And more importantly, he's entitled at any point to seek what's called an Arthur hearing. An Arthur hearing is a bond hearing for people who have non-bondable offenses or who are being detained without bond. Now, it's a little tricky in this case if he's entitled to bond on both of his charges and the bond judge made a finding of fact that he presents a danger or a flight risk, then there may or may not be an Arthur hearing because you need new facts. You're going to have to come up with what they call a substantial change in circumstances to re-argue a bond issue if it was fully vetted. But if the public defender was smart, which most of them are, they wouldn't touch it if that was the case, and they would simply reserve their right to make a bond hearing, a bond argument at a later time, stipulate for the time being, and that way they can sit down with the family, they can sit down with the defendant, Mr. Hills, they can get his version of events, they can try and piece together whether there are any mitigating factors or any issues that would question or attack allegations by the state that he either is a danger to the community or a flight risk. And one of the most obvious in this case is whether or not he acted in self-defense or pursuant to Florida's stand your ground law. And we'll get to that a little bit later. So let's kind of run through some of the charges. Attempted second-degree murder. So second-degree murder is not an intentional killing. It's a depraved killing. It's a killing that's done in a reckless manner as a general rule. And attempt means that you tried to do it, but you didn't actually do it, but you had the intent. You wanted it to occur. For whatever reasons, it didn't happen. So let's pull out of the murder and let's talk about bank robbery, right? Martinez and I decide that we're going to rob a bank. We find the bank, we plan it, we case it, we get our guns, we get our ski masks, we decide we're going to do everything, and we have a third guy involved, right? And the third guy, unbeknownst to us, is an undercover confidential informant who's working for the FBI. Before we ever get to the robbery, for whatever reasons, say Martinez decides he wants French fries from McDonald's, or I decide I have cold feet and I want to call it off, or we pull up and the bank is closed. Well, we don't get to do it. But if we've taken sufficient steps towards accomplishing that objective, then we meet the criterion for an attempt. And in Florida, any attempted crime is scored one level below the offense itself. So second-degree murder, which is a first-degree felony, would score as a second-degree felony because it's an attempt. So aggravated battery. Battery is an unlawful touching. It's that simple. You could spit on someone. That's a battery. You could slap someone. That's a battery. If you use some extraneous piece of equipment or tool or weapon, then it can become aggravated by way of having a weapon. You can have a baseball bat. You could throw a lamp at somebody. You can have a firearm. Any of those things will ratchet up the offense. And of course, in Florida, we have a little ditty called 1020 life. And the 1020 life law means that if you brandish a firearm during the commission of a crime, if you actually display, if you have a firearm and you display it, that subjects you to 10 years. Minimum mandatory day for day, above and beyond, regardless of whatever your sentence is. So even if you had a third-degree felony where you were subject to 1020 life, you could be looking at a 10-year minimum mandatory. 20 years comes into play if you actually discharge the firearm. So if I pull that firearm and I brandish the firearm and pull the trigger and actually discharge a projectile, whether I hit anyone or not, that's 20 years. And life, of course, is if you touch somebody or much less kill them. So the charges are very serious in this case. They're ratcheted up by the fact that there's a firearm involved. Now, again, I don't know Mr. Hills. I don't know if he has out-of-county or out-of-state priors, but let's assume that what I was able to find is all that he has, which is a aged, years-old misdemeanor marijuana possession. He's not prohibited, at least as a consequence of his criminal history. There may be other factors that I don't know of. Maybe there's a restraining order. Maybe he has been declared incompetent or Baker acted. But again, all things equal, now that Florida is a constitutional carry state, if he's not disqualified, he's entitled to possess that firearm. But possession of a firearm and use of a firearm, brandishing, much less discharging, are two completely different things. So what happened between Mr. Hills and his alleged victim? Nobody knows. Even the article that I read doesn't really tell us what happened. All that it says in the article is that there was an argument. I'm sorry, I'm looking back at the article. He was identified as the shooter. There was an argument between the victim and a witness. I'm assuming they mean the victim and the defendant. The dispute became physical. Both parties were separated. Maybe it was an individual third-party witness and the victim was shooting, and Mr. Hills just happened to observe this. And just bear note of that because, in fact, I'm going to write it down real quick. Because the law of self-defense and the law of stand your ground in Florida doesn't just apply to you. It can also, in certain circumstances, extend to your property, and it can extend to what we call defense of others. So if I'm walking through a parking lot and I see a woman or a man being attacked in the parking lot by somebody, I can come to the aid of that person legitimately. Now, should I? Well, that's a whole different story. In my experience, Good Samaritans usually finish last, but that's an individual judgment call, and some people would want to involve themselves, other people wouldn't. So it is possible. Again, it's cryptic. I haven't read the police report, and I'm operating on this limited article here from the news. But it appears that there was some argument between the victim and somebody else, whether it was Mr. Hills or a third party. The dispute became physical, and the parties had to be separated. It's unknown who separated those parties. Could be that the victim and a third party, there's Martinez. I'm still going through the facts, Ed.
Oh, go.
So what we're talking about right now, what happened and how we don't really know. And I'm saying that it's based on what I'm reading here, it's entirely possible that there was an argument between the victim and a third party witness that Mr. Hill observed, and that either he or somebody else involved himself in that physical altercation to which he had nothing to do. And pursuant to Florida stand your ground or self-defense laws, you are entitled to be a good Samaritan and help somebody else if you believe that you are acting in defense of others. In any event, police said that once the argument left, Hills left the residence. Now, again, whether or not this happened in a residence, whether Hill was the individual in the argument, we don't know. But he gets into his vehicle. He begins to reverse when the victim grabs a glass bottle from the home and throws it at Hills's vehicle. They add in this superfluous language, but did not strike it. Shortly after the victim threw the bottle, Hill pulls out a handgun, shoots the victim, and flees. So was Hills acting in self-defense or defense of others? Possible. Don't know. Question now becomes, where and when does that line get drawn? So the law in Florida is pretty clear. You are entitled to use that amount of force, which is reasonably necessary to combat the amount of force that's being used against you. So in other words, if I threaten Ed with my fist, he's going to have a very hard time defending using a flamethrower in defense against me. Now, on the flip side, many of you may have seen the great Untouchables movie with Kevin Costner and Sean Connery, and you may remember that line where Sean Connery's attacked at his home by a bunch of Italian mafiosos that work for Al Capone, and the guy shows up with a knife, and Sean Connery walks out there and says, "Oh, just like a wop to bring a knife to a gunfight." Well, that's kind of analogous here to the law of self-defense. You may be able to bring a knife to a gunfight depending upon how you perceive it and how it's objectively perceived by others. But I would say if somebody throws a bottle at your car while you're in your car driving, unless that bottle is a Molotov cocktail, you're going to have a hard time justifying stopping your car, pulling out your gun, and shooting that person from behind. But again, who knows? That's a stand your ground argument that Mr. Hill's lawyers may ultimately make. And it's one of the reasons I had mentioned to the folks, Ed, I know he's being held without bond, but he's got bondable offenses. Right. Attempted second-degree murder should have a bond. And aggravated battery with a firearm certainly has a bond. So the judge must have made a ruling that he was either a flight risk or a danger to the community and held him without, if the article is to be believed. So how do we know what happened? We don't. Now you know everything we know. So how does law enforcement get involved in this matter? We're not sure about that either. Somebody must have called 911. Somebody must have dialed 911 and said, "Oh my God, there was a shooting." Somebody reported the vehicle.
Could have been somebody who was involved. Could have been an anonymous tip. Could have been, somebody who was watching and left their name, but were not involved. There's just a slew of different reasons. Somebody heard a gunshot. Could have said, "Hey, I heard a gunshot. I think it came from my neighbor's house." So there's a slew of different reasons they could have been involved.
And so however they get involved, they show up on scene, they determine that somebody has been shot, they get a witness statement from somebody that the individual who committed the shooting, the guy with the gun, is driving a particular type of vehicle and fled in a particular type of direction immediately after the shooting. That means there is an eyewitness to the shooting, at least according to the article. And if that's the case, then what the police do next is actually very good law enforcement protocol. It's what you would want them to do. They put out what's called a BOLO, or a be on the lookout. They get on their little police radio and they say, hey, dispatch, tell all units to look for this particular type of vehicle traveling in this particular type of direction with this description of this particular individual inside of the car, and be aware that it's a firearms case. It involves a shooting, use extra safety and caution. So every police officer on the police band is getting that transmission. And every cop that's out on shift is hearing it. Now they're all highly focused because they don't know the why of it, right? They may assume a worst case scenario. They may make no assumptions at all. But they do know that there's somebody shot and that there's another person who fled the scene with a gun, and they need to get control of the situation right away. So they put out this BOLO, and lo and behold, other police officers, not the ones who are on the scene, but other police officers who heard the BOLO observe a vehicle that matches the description, and they make a stop of the vehicle. And what do they observe when they stop the vehicle? According to the article, the first thing they see is a gun on Mr. Hill's lap, assuming that Mr. Hill is in the driver's seat because it doesn't indicate that anybody else was in the vehicle. Again, we haven't read the police report, so we don't know, but let's just run with that for a moment. So Hill, if you were to believe, Hills stops his vehicle, either shoots from inside of the car or exits the car and shoots backwards, strikes the individual, gets back in his car or turns around from inside of his car and drives off, and then puts the gun on his lap while he travels however many miles, at least 7-8 miles from the point of the location of the incident to where his traffic stop is, if you're just doing sheer calculating the numbers of the street addresses. So, some degree of distance, and he's just driving around with the gun that he just shot somebody with sitting on his lap. So the police officers see the gun. This is what we call plain view. If a police officer makes a traffic stop of your vehicle for anything, any reason, it could be speeding, it could be you were involved in an automobile accident and they responded to the scene. They could pull you over for weaving. You could have a defective taillight. You could be sleeping on the side of the road. If for any reason John or Jane Q police officer walks up to the driver's side of your vehicle and looks in your car, anything that they see is fair game because they're legitimately where they are entitled to lawfully be, and they're making an observation of something with their plain eyes without doing anything to enhance their vision. They're not tearing your car apart. They're not looking under your seats. Whatever is physically there in plain view, which is why we always tell people, don't drive around with an open beer. Don't have a open bottle of wine that you didn't finish at dinner sitting on your passenger seat. Put it in the trunk or leave it at the restaurant. But in any event, anything that's in plain view is now automatically in. There's going to be no argument to suppress that firearm, especially if the officers who conducted the traffic stop were wearing body-worn camera and their video is showing exactly what it is that's being reported.
But let me point something out. The reason that Michael is talking about plain view is because of the introduction of evidence, okay, that the cops can take that evidence. In this case, it applies. If I was driving down the street and a cop pulled me over and I had a gun in between the seat and the console, or even if I had it on the passenger seat, and I haven't committed any crime, I haven't done anything, cop just pulls up next to me or I'm parked on the side of the road and he just looks in. That's not really plain view because he has no concept that I've done anything illegal. However, he's got a call that somebody says that this guy shot at somebody. Before that, they were fighting. He fled the scene, which is also part of, consciousness of guilt. And there's a firearm. Now, that officer absolutely has to take that firearm because he's got more than just some dude standing on the side of the road with a gun.
I want to add one thing to that, and that is, you are not allowed to drive around in the state of Florida with your gun sitting on your passenger seat of your lap. That is a crime. Yeah. That is called unlawful exhibition.
Well, if you're transporting it, but that's why they hire us.
It can't be in plain view. It's not allowed to be in plain view. It's got to be encased. It's got to be in a holster or a case, or it's got to be concealed on your person. again, constitutional carry allows you to conceal carry without a
But you
permit,
can
not to open
you
carry.
can also transport, but you should always transport unloaded or in a pouch. Now, I wouldn't even put personally. I would tell you as a lawyer, don't even put it in a holster. If you're going to do that, put it in a pouch or transport it unloaded.
And I would add to that, if you're going to shoot somebody, don't drive around with the gun that you just shot somebody with on your lap. Because they're gonna take that gun, and the first thing they're gonna do is send it over to the Metro Crime Lab for ballistics examination, and then they're gonna match it up to the slug and the guy who's lying on the ground in the parking lot where you shot him. And you know,
I don't know if you want me to go through eventually later on, like the mindset of a prosecutor if a prosecutor got this. Okay.
So well, let's just kind of run through the rest of the fact pattern, and then we'll do that. I talked a little bit about what the prosecutor probably would have argued at the bond hearing. But I want to go more into it, and that's exactly what I'd like to do. But let's run through these bullet points again, because one of the things that this article goes on to say is they take this guy into custody, and they say, after allowing Hills to drink some water and smoke a cigarette while being interviewed. All right, let's just stop right there for a minute. That I am very comfortable in saying that the news reporting agency probably did not make that up. They probably took that language directly from the complaint arrest affidavit, the sworn statement of probable cause. And the police, no doubt, intentionally incorporated that language into their police report so that they could show empathy and how they were doing such a courteous interview of this individual that they gave him water and let him smoke a cigarette, as opposed to grilling him about the shooting that they believe that he just committed, right? So it's like, look, we'll let you have a sandwich, you could take a nap, relax a little bit, we'll get to talking about this later. It's just a typical tool that intelligent law enforcement officers, detectives will use to try and bolster the credibility and the admissibility of any statements. So they say that this is happening during this time while they give him water and to smoke a cigarette while being interviewed. Ed's going to chime in on that in a minute. And Hills asks detectives, quote, "Is this about a homicide?" So there's a lot to unpack there. And Ed's going to talk a little bit about custodial interrogation and Miranda. But the one thing I want to say before he gets there is, when you offer statements to law enforcement, if you blurt out something like, "Is this about a homicide?" the vast majority of time, that is going to be considered what we call a spontaneous statement or an excited utterance, meaning it's an exception to the hearsay rule, and Miranda does not apply. Even after you have been Mirandized, if you invoke and you say, "I don't want to talk to you until my lawyer's present," and then you blurt something like that out, it's coming in, because you have now waived Miranda and restarted that clock. But with that said, right now, we don't know what the status is. We don't know where it is. We can surmise from this short paragraph, because they say Hills asked detectives. These are not the cops on the roadside that pulled him over. He must have already been transported back to the police station, because the detectives are not going to where he is. Believe me, they want him in a room at the police station. They don't want him on the roadside. And if they allowed him to drink water and smoke a cigarette, they probably gave it to him in an interview room as well. So, Ed, where are we from a prosecutorial standpoint with regards to statements at this juncture, noting that, I have to say one more thing, because they say after that, investigators brought Hills into an interview room where he stated that he wanted an attorney present. So he gets a water and a cigarette while being interviewed by detectives, but then he's brought into an interview room where he says he wants an attorney present. Unpack that load of horse crap.
You want me to do just that, or you want me to take you like step by step and eventually where a problem?
However you want to do it.
I think what I'd like to do, because I might actually have to go back. I'm still on Zoom in the courtroom, but he's going in order, and I think I'm going to be an hour before he gets to my case. Seriously, very nice judge. He seems like a very nice man.
Which is the only reason that you're in a suit and tie.
Yeah, exactly.
And had I known that you had a Zoom hearing, I would have worn a tie and a shirt too today.
So just
instead of my Guayabera.
Just based on what we have, right? A prosecutor will get that, but a prosecutor still has to set what's called a pre-file conference, where the cop will come in, we have to put him under oath, swear him under oath, and then he's going to tell me fill in gaps. I'm going to show you where the gaps are. That's what would happen when I talk to the cop. But I would first get this report, like what Michael's reading. It seems like whoever the news media is that got a full arrest affidavit. So they pretty much wrote what was in there. So the first thing I'm looking at is, okay, like Michael said, there looks like there was a fight between a couple of guys. Mutual combatants, looks like everybody's fighting. Not a crime there. What else do we have? What's the crime? Oh, wait a minute. One guy drove off and the other guy threw a Molotov cocktail at him. First thing I got to ask myself as a good prosecutor is there going to be a stand your ground issue? Now, remind you, I'm looking for probable cause at this moment because right now the arrest was made by a cop and the cops only have to get to the threshold of probable cause, which is not as high as a prosecutor. This is a good time for me to explain to you what probable cause is. And the way I used to explain it at the academy, which is the easiest way I think for everybody to understand, is after the officer gets as much information as he can on the scene, is it more probable than not that a crime was committed by a certain individual? That's it. That's it. That's all he's got to get to. If he can get to that, he makes the arrest. If he can't, doesn't mean he doesn't eventually make the arrest, but that's where he would come to a prosecutor like I was in a special unit and say, this is what I got. I don't think I got probable cause, so I want more. So,
oh, Ed, let me cut you off for 1 second. I apologize because I just pulled up the docket again, and it's showing for current bond status. You'll love this. This is great. We must be wrong because the article I read said that he was still in custody, but this says that on 9/29, the day after he was taken in, which means he went to his initial appearance within 24 hours as he's supposed to, current bond status, no probable cause for count 1. Released outright. Probable cause found for count 2, bond set at $10,000.
Count 1.
Huh?
What did they?
Count 1 is the murder.
Murder.
Count 1 is the attempted murder. They found no probable cause.
Okay, so let me go through this. Now, was the person he shot, the person was shot, right? The person was hit with the bullet.
I guess, yeah. I mean, that I don't know.
I honestly, I don't know because I think there's at least probable cause for that because once you shoot a gun at somebody,
but maybe he wasn't hit. Again, we're making assumptions.
Yeah, we're making assumptions. I suspect that maybe he wasn't hit. I suspect he may not have been hit. And a good defense attorney made the argument that, yeah, he fired a firearm, but he didn't necessarily fire in the direction.
Well, but then how do you get the ag bat with a deadly weapon?
That's what we'll cross that bridge when we get there. Let me go through as a prosecutor. So you're going through and you see that a Molotov cocktail was thrown at the defendant's vehicle. And like Michael said, that's not going to be a stand your ground. He had no right to come out of his car because somebody, not a Molotov, just a bottle was thrown at his vehicle with him in the vehicle. So that's done. So let's keep looking. And then he gets out of his car and he fires at him. Okay, we've got an improper display. We've got an improper discharge because we go through all the elements. Improper display of a firearm is a misdemeanor. Improper discharge, I believe, is a 3rd degree, right? Felony. Is it still a misdemeanor, improper discharge?
It depends where.
Right. But since what we're reading in the report says that he fired at an individual, now we're getting into the area of an aggravated battery with a deadly weapon because a firearm is a deadly weapon and possibly attempted 2nd degree murder. But now comes the part where Michael's bringing up that they found no probable cause. In order to prove attempted 2nd degree murder, as a prosecutor, I'm looking at the report and I'm saying, well, where is the intent? Did he fire at that individual? Because if he fired directly at him, then we could say, well, there was an intent to kill because you shoot somebody with a gun, there's a good chance you're going to kill him. Or did he just fire it and maybe nobody been able to say, well, I didn't really see him pointed at me, right? I'm sure the prosecutor brought in the detective and he said to the detective, hey, did anybody see him pointed at the guy or did somebody just hear a gunshot? Which is probably what happened, Michael. They probably only could say, well, we heard a gunshot, but we don't know where he pointed it at. That would be a reason. Now, again, I'm just guessing, but that would be a reason for no probable cause because how do you know he meant to shoot him if you don't know where he was pointing it at? He might have been shooting it in the air to scare people. He may have been shooting it at the ground. That wouldn't get you to the attempted 2nd degree murder.
Discharging a firearm in public or on residential property, Florida Statute 790-15, subsection 2. Any occupant of a vehicle who knowingly and willfully discharges any firearm from the vehicle within 1,000 feet of any person commits a felony of the second degree.
Okay, I thought it was a third or second degree. So, but again, it sounds to me like they may not know if he pointed it at anybody, which then leads us to what Michael was saying. But if there's no probable cause for attempted murder, how's there probable cause for the ag bat with a deadly weapon?
You know, this is, again, what I started the show with was explaining how important it is for us to have that police report.
This is the question as a prosecutor that I would be making when I was a prosecutor. Well, he says he shot, but did he shoot at somebody? Did he hit somebody? This is what the pre-file conference is for. When a detective comes in, which I'm sure this guy must have hired a good lawyer. The PD did a very good job, and they probably brought in the detective for the bond arraignment. If they didn't, that was a huge mistake.
And you mean the state?
Huh?
You mean the state?
The state. Huge mistake by the state, because that's probably why they dismissed on probable cause. Now, let me bring something up. Just because the judge found no probable cause does not mean that they cannot come back around and charge him if they get probable cause, or honestly, when it's the state attorney who's looking at it, right? So going back to me as a state attorney, I need to find beyond a reasonable doubt. Like, I first look at it under probable cause, because if there's no probable cause, I'm not going any further. And I know I got to go in and tell the judge, this needs to be no action because there's just not enough here. Doesn't mean the investigation stops. Just means right now we don't have anything. But if we have probable cause, I got to go to the next step, right? So let's say we did find probable cause. Like, they did find probable cause on the ag bat with a deadly weapon. State attorney now has to look at it and say, okay, but is this probable cause? Or can I prove this beyond a reasonable doubt? Because if a state attorney doesn't feel he can prove it beyond a reasonable doubt, he still should not be filing those charges.
You know, the truth is we don't know, because again, we haven't read the police report. So we're doing a lot of assumptions, and it just goes to show you how bad assuming is, because I assumed that he was in based on what I read in that article. Yeah. And now looking at the docket, we find he's not.
Yeah, but the reason I like this story is because the audience can see if this were happening to a state attorney, right? When I was there, I'd be saying, Judge, well, in this case, they did it at the arraignment, but I'd be saying, I got 21 days. I need that detective in my office because I just don't have enough.
Well, it's not like, look, at the initial appearance, they don't litigate the case. The only purpose of the initial appearance is to determine whether or not you're going to be pretrial detained or released. And if you're going to be released, what conditions are necessary for your release. That's all it is. So it's got no bearing on the ultimate end of the case.
But they should have had a detective at that. And you do that. Sometimes, you'll get a good defense attorney or a good public defender who's a defense attorney who you'll know is going to make that argument at the bond arraignment. And if you already know that, most judges will let you set it one extra day for you to get the detective in if it's important enough for you not to let him out. Maybe not, Michael. They may have looked at his priors and saw I think he has no priors or one minor prior. And the state might have looked like, you know what, it's not worth it. We'll regroup and we can.
Well, again, remember, we haven't read that report. So as I'm thinking about it now, it's just as possible now that I'm reading this, that this was a domestic dispute between him and a roommate or, somebody else. And it may be that the ag bat with a weapon may not even be a firearm. There may have been something that happened inside of the residence that had nothing to do with the shooting in the parking lot. And maybe nobody was actually shot in the parking lot as opposed to somebody actually being struck with a bullet. We just don't know.
I suspect that what happened is nobody saw him pointing it at anyone and they heard the gunshot. But again, that's just an assumption. So
well, again, the most important thing would be whether or not there was another person that was struck by a projectile from his firearm. That's the big ticket item right now.
Yeah. Now, because if it is, there's no doubt it's at least second degree murder. So let's keep going. So now they get to him, they stop him. They have every right to stop him because there's a bolo. So there's some reasonable suspicion, which is
right. Well, it's what we call a probable cause stop.
So he stops him and he starts asking him. They take him in. Now let's go into custodial interrogation. That's the key on Miranda. The key on Miranda, which is what I also used to tell the officers in the academy, stop calling it Miranda and start calling it custodial interrogation. Because if you have one but not the other, you don't need to read anybody Miranda. If you have both and you want to be able to introduce the confession, you have to read a Miranda. So let me unpack that for you. If he's in custody means, and the Supreme Court of Florida hasn't determined exactly what custody is,
It basically means you're not free to leave.
but they have said this. We don't know exactly what is and isn't, but we know this. If you're in handcuffs, you're in custody. I don't care what the detective says. I don't care if he said it was for officer safety, or if he puts you in cuffs, you are absolutely in custody, regardless of what the reason was for putting you in handcuffs. So if somebody's in handcuffs, they're in custody. And if you're in handcuffs, the officer then cannot interrogate you. What is interrogation? Asking you specifics about a case or a situation that could cause to a crime. In other words, asking Michael Haber when he's in handcuffs, what's your name, is not an interrogation. Asking him, bro, what happened? That's an interrogation. So if they said to him, hey man, just get out of the car. What are you guys stopping me for? I'll tell you in a minute. Just come with us, relax. I got to put you in handcuffs for now. You want a cigarette? Yeah. You want some water? Yeah. Okay, chill. Hey, is this about the homicide? No problem. Put them in handcuffs and say, what happened? Problem. No.
What if they put him in? What if they detain him on the side of the road?
Right.
They take him into custody. They put him in handcuffs. They put him in the back of a patrol car. They transport him to the station. They remove the handcuffs.
He's still in custody. He's still in custody. He's still in custody. If you're at the station, you're still in custody. You
Against your will, because you can't leave.
You can't leave. Like, what are you going to do? Run out the door? No.
Oh no, I mean you could run out the door if you could, but the point is you're not free to leave, and that's the distinction between
But
custody and
the flip side. Now, in a situation, not this situation, because in this situation they had probable cause. But let's look at a situation where you're stopped or a cop comes up to you and he doesn't have you in handcuffs. He hasn't taken your driver's license. He's just sitting there chatting with you. He says, hey, Mr. Haber, I just got a report about a shooting down the street. Do you know what happened? That's fine, because Michael's not in custody. While it is an interrogation, he's not in custody. So
but again, that goes back to that concept of freedom to leave. It's the three tiers of what we call police citizen encounters. The least restrictive is just that. It's called an encounter. Any police officer, like any other person on the planet, can walk up to anybody anywhere and ask a question. The other person is free to.
The reason I said he doesn't have your driver's license, because there is case law that says if a cop is holding your driver's license, you're not free to leave. So, like I said, no driver's license. And I'm just
right. So an encounter, but an encounter is a voluntary situation.
Right.
That either party is free to walk away from. A detention is the next level, and that would be where they've got your driver's license. You are being detained on the roadside, and the Fourth Amendment is implicated. You are not in custody, but you are being detained.
But this is why I said all this, Michael, because it's extremely important for everybody to understand this. An officer does not have to tell you you're in custody or you are free to leave for you to be in custody or free to leave. Okay? So it's crucial, in my opinion, to everybody who's listening. If you are ever talking to an officer, whether he's in uniform, undercover, on duty, or off duty, okay, you must, when they say, hey, can I talk to you for a second? Your first words should be, am I in custody?
All right, am I free to leave?
And if he says no, say, no, you can't talk to me. That's it. Because this is their job. And I'm not judging them. This is their job. Their job is to get you to confess. That's why they're talking to you. What do you think? They like you? They don't like you. They don't want to invite you to their barbecue or their birthday party. They're only talking to you to try and get a confession out of you about something. So if you are asked by an officer, can I talk to you? Am I in custody? It's that simple. So now in this case, I don't know. I suspect he was probably in custody when he made those statements. Now, if the officer said to him, hey, man, you want to tell me your side of the story? They better have read in Miranda. Now, one last thing I want to say about Miranda. Clients tell me this all the time, Michael. I don't know about you. They didn't read me Miranda. That case has to be dismissed, right? No. Miranda only means if a cop violated your Miranda rights, that confession can never be introduced. That's it. They can still make the arrest. They can still do everything else. It's just that
the gun comes in, the bullets come in, the witness statements come in, but your statement does not.
Let's go back to being a prosecutor. So one of the things as a prosecutor that I'm tending to think there's definitely at least probable cause is that statement. If the officer had not told him, hey, we got a call about a bolo and a shooting over here, blah, 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 and that guy just spontaneously said, hey, is this about the homicide? That's something in the law called consciousness of guilt. That with the fleeing are both consciousness of guilt that a prosecutor can use against you. So you may think
that would be what we call circumstantial evidence.
right. You may think a very simple question like, hey, is there a homicide? Doesn't mean anything. It tends to, it's like if you ask your husband or your wife, hey, honey, you were half an hour late. Where were you? And they say, what do you think I was cheating on you? What's the first thing you're going to think? Well, I didn't say that. Why would you bring that up? Well, it's the same concept in the law. If nobody asked you, why would you mention that? So his statement, if it comes in, is going to be a problem for his lawyer.
But I think the real big takeaway from all of this is, and it just goes to show you, because even Ed and I, or I, made some assumptions based on the article that are not accurate. And so, look, again, I personally, I'm not a big news guy. I don't trust the news. I don't care what station you watch. I don't care who you listen to. They're all full of crap. They all have an agenda. They're all pushing a narrative. And it's the days of the Walter Cronkites of this world of impartial and truly unbiased reporting are pretty much dead. Not completely, but for the most part. So, it would have been really nice for this news network to attach that arrest affidavit to their article, because that way we'd know what's going on. And what would be even nicer? If our clerk of court were up to speed with the Florida Supreme Court rules and did what they do in Broward and the rest of the state of Florida, where we could read that document, and then we wouldn't be guessing as to what happened.
Right.
We'd still be guessing about things like what occurred at the bond hearing because we weren't there and we can't read the minutes of that hearing. But we can get a much better feel when we read that police report, because if you're going to levy charges against somebody, that's your sworn statement. You damn well better hit every element of every offense charged in your police report. Doesn't mean that you're going to write a book like Ulysses, but you do need to hit those points that align with the elements of the offenses that you're charging. And there's got to be a factual predicate to support them.
I agree. So that's pretty much where I think as a prosecutor, from what we've read in the article, if that's all the prosecutor has, in my opinion, in my humble opinion, under no circumstances could a prosecutor file charges based on that. He'd have to have a pre-file, bring the detective in, right, and say, okay, listen, you say he shot, but did anybody see him pointing at the guy?
Remember, in fairness,
in the wall behind where the victim was standing, you could probably charge second-degree murder, but you need to be able to prove the intent to do it. And shooting a gun is not necessarily intent to kill somebody if you shoot it into the ground or you shoot it up in the air. So they need more. Maybe that's what happened. Maybe they didn't have in there, and the detective didn't show up to the bond arraignment, and they probably didn't put in there that he was pointing it at it. And a good defense attorney said, Judge, all they said is that he fired the firearm. It doesn't say that he pointed it at the victim and fired it at him. So.
Well, I agree. And so again, as to Mr. Hills's case, until we know exactly what the facts are, when we read that police report, we'll be in a better position to be able to opine. But for right now, what we do know, based on that limited, cryptic newspaper report, coupled with looking at the clerk's docket, is a judge found no probable cause for attempted second-degree murder.
But remember, Michael, it's not over yet. The state.
No. Listen, the state may be able to charge him with a billion things, including they may be able to charge him with attempted first-degree murder. I don't know. I don't know what happened. That's kind of the point.
It doesn't mean it's gone forever. All the judge said is right now you don't have enough.
And they may be able to stack a slew of other charges on him, above and beyond that. Ag assault with a firearm, unlawful discharge of a firearm, shooting from a vehicle. All of these types of things may or may not be applicable in the case. But Ed brings up a very good point. And to the extent that the public defender is able to do this, and both Ed and I have a great deal of respect for public defenders, they are far from stupid. It is not easy to get a job as a public defender, especially here in Miami-Dade County. I mean, everybody who wants to be a public defender in the country wants to be in Miami, New York, LA. They want to be in the big cities. They want to be in the big jurisdictions. There are literally thousands and thousands of applicants for each slot. So only the best of the best and the most committed get the job. And then getting the job is one thing. You got to be good enough to get it, but you got to perform to keep it, because Carlos will throw your ass out of his office if you're not performing. So public defenders get very high marks in our book. Here's where the tire meets the road, though. What they don't have is small dockets and small caseloads to be able to dedicate. I mean, unless you're talking about somebody who's in the capital litigation unit with a limited number of cases. Pit public defenders have to deal with a enormous audit, just like prosecutors have to deal with an enormous audit. So to that one extent that private defense lawyers, at least scrupulous ones that don't just sign every case that shows up in the door and budget their time and manage their caseloads, we generally are able to offer more attention and, as I like to call it with my practice, boutique services to our clients. So in a case like this, you've got an opportunity in what Ed talked about, that pre-filing phase, the time between the moment of the arrest and the time between arraignment, when a prosecutor ultimately files charges or announces that they're not filing charges. That interim period, the burden is on the state attorney, and they do this in every felony case because they have to. This is a absolute job requirement. They have to conduct pre-file conferences. Now, oftentimes there are other state attorneys that are specifically assigned to do nothing but pre-files and never step foot in a courtroom, right? But the point is, somebody needs to pre-file the case. Somebody needs to read that report, call in every relevant witness to that case, look at all of the evidence that they can be exposed to, and then make a very informed opinion as a lawyer as to whether or not there is an ethical mandate to move forward, and if so, with what charges. And in that, I know you want to say something, but hang on one second. It is in that window that let's just generally call it the 21-day window. Again, it can be extended, but it is in that pre-filing window that private defense lawyers can be extremely effective and extremely aggressive with the state in trying to affect that filing decision. Go ahead, Dick.
And on that note, again, going back to what the prosecutor thinks of at the intake stage, right, where they're looking at the police reports and talking to the officer to decide whether or not he should file. Now, remember, ethically speaking, now that doesn't mean that a prosecutor is unethical when he does it. Some don't even realize this, Michael. I've spoken to some prosecutors. Some of them don't even understand this. They've not been explained this. The prosecutor should not file a charge unless he gets enough evidence where he thinks he can prove it beyond a reasonable doubt. Now, he'll get the cop in, and the cop will tell him, hey, we saw this, that, and the other, and maybe one witness or not. When the prosecutor gets to the point where he says, I've got enough to prove it beyond a reasonable doubt, he pulls that trigger. What does that mean? Why do you need an attorney to talk to him before he can pull that trigger? Because it's not the state attorney's job, nor is it feasible for him to find exculpatory evidence, right? The cop is not going to tell him, oh, and by the way, there was another witness who said that this witness is full of shit. He's not going to do that. They don't do that to the state. They don't tell us.
Well, let's take an example here.
Hold on. We may not know that there's another witness out there that's going to contradict one of our witnesses because they don't tell us that at the pre-file. We find that out with the discovery stage where the defense attorney comes in, he starts talking to people, he hires an investigator, and then he'll come to me when I was with a prosecutor, Mike would come to me and go like, Ed, you know that witness that you said XYZ? Yeah, you know there's another witness, or you know he wasn't even in the state, or you know, oh really? I didn't know. Bring that to me.
Let's take an example here. It's entirely possible that the reason that Hills, if he in fact stopped his vehicle after the guy threw a bottle and turned around and fired around at him, perhaps that person had a gun pointed at him.
Correct.
So, we don't know that. And if that were the case, then you might have a legitimate, justifiable reason for him to have pulled and discharged that firearm.
Correct.
So defense counsel, we're tasked with trying to figure out explanations, rationales, justifications, legal, we can call them excuses if we want, but bases upon which to defend whatever allegations the cops made. And if we are able to successfully bring them to the state listens, which oftentimes they do. I've had more than one aggravated assault with a firearm charge, no action, because the prosecutor has listened to me and I've involved myself in the pre-filing stage to show that my client was actually legally justified in doing what he or she did.
Right. I agree 100%. So I think that reaches us to the hour, my friend, and believe it or not,
Yes, it does.
I got to go back.
I want to wish Mr. Hills the best of luck. Again, I started this by saying no matter what, he's presumed innocent, as is everybody who's accused of any criminal act anywhere in this country. He should not be convicted by any of us, especially since we don't know the facts. And if anything you should get from this hour that we just spent together is you got to know what you're talking about before you talk about it, because I was halfway through this thinking that this guy's sitting in custody right now until I looked at his court docket and saw that he wasn't. So there you go. Your defense lawyer should be vetting things for you. Your defense lawyer should be taking your case to the state rather than sitting and waiting for the state to bring the case to you. If plausible, it's not always possible to do it, but if it is, take the fight to them. With that, Ed, thanks for joining us. Go get back to your Zoom before you're held in contempt.
I gotta go, everybody. Bye. Thanks, Mike. I'm leaving. I'll let you sign everybody off.
All right. We're not going, little programming note. We are not going to have a show next weekend. Next Monday is Columbus Day. Yes, I did say that. It is Columbus Day. It is not Indigenous Peoples Day or Native Americans Day. You're free to believe that if you wish. But as far as we're concerned, it's Columbus Day, and we will be putting out a PSA of the day as to why we believe that. But in any event, feel free to call it what you like, do what you like, enjoy the holiday. It is one of the Uniform Monday Holiday Act days, so it is a 3-day weekend, and we want you to enjoy it thoroughly, no matter whether you celebrate anything or not. With that said, thank you very much for joining us. I'm sorry that I rambled as much as I did. It would have been a little better if Ed were on sooner, but you know those judges, sometimes they just don't cooperate. Anyhow, you all have a great week, actually a great 2 weeks, and hopefully we'll see you on the 16th with episode number 77 of At Your Service with Haber and Martinez. We're proud to be at your service today. Thank you again. And as soon as our show gets uploaded to social media, we will be providing links on YouTube. Thank you again. Appreciate it. Thank the folks at Miami's community newspapers for their kind time, effort, and professionalism.